This is Jeff Fowler with the Apartment Owners Association, and it is great to have you with us today. We're talking about addressing noise and nuisance tenants, and it's interesting how this has been something that's been coming up more. And so we have a incredibly seasoned attorney, the king of evictions, is with us today. Before we get into that, definitely. Just we want you to know we are here to help you uh, make more money or save more money, and definitely nuisance tenants are going to drive out your good tenants, and you need to get out the bad ones and not have the good ones go out, obviously. So before we get into that, just want to mention that if you have a 16 unit building or more, you are required to offer rent reporting to your renters, your existing renters, and also with every new lease. And anyway, if you haven't been compliant with that, your AOA membership includes that service, not for free. It's $5 per unit, but that's something that AOA is offering to you. So we have the forms that you need to include on your lease agreement. If you need help with getting compliant with that, we have like suggested email that you could send out to offer it to your renters and get you started on that. And in just the last week, we've also been able to make it so it's not just where they're able to build their credit over time, but we're also even able to go backwards 24 months, and so they could see a boost in their credit. So we have the nuisance tenants, but then we have the good renters as well, and this is a way to reward them. And rewarding good behavior seems to really work. That's an option that you have here. So I hope you're able to um, to give that a try or learn more about it. So rent reporting, and you would just contact our tenant screening office, and they'll be able to get you to the right people. And anyway, if you're already doing tenant screening with us, it's pretty simple. And on a monthly basis, you give us the information on those renters that do want to do it. And it's also kind of a nice screening tool as well. You can ask renters if they want to opt into that before you when you're in the screening process as well, and that may show you who's actually going to might end up being a good renter or not. And anyway, over the last 2 weeks, we've had 8 in-person seminars, and we have a couple more that are coming up in November. In November, we're going to be in Sherman Oaks and in San Diego. We're going to cover landlord tenant. We'll have different landlord tenant law attorneys speaking on the eviction process and security deposits. One that we just had up in Fremont was about how to lawfully deny someone who has a criminal record when you're in the tenant screening process. And a lot of people, they just avoid it completely. Some people are mistakenly believe that they can't deny anybody, period, if they have a criminal record. But actually, you can. And because we have the tenant screening, we know that we're returning results, and we want to help you with that process and give you some ideas and just best practices. So we did one just a couple days ago. We did one in Fremont. We recorded it. We're working on getting that edited and put together so that everybody could have that. Even though it's up in Fremont, it does cover. It applies to the whole state actually. And there's a thing called an individualized assessment when you see a criminal record there, there's a process that you need to take, a series of questions that you need to ask yourself and how it relates to the renters, your existing renters, and how, just a lot of different things that you look at there. And so we'll have a checklist that goes with that. And anyway, it's really a best practice to use that guide when you're actually looking at the those criminal results. So very excited that we're able to put that together. That's something we are not just going to put out on YouTube. That is going to be for members only. So some of our content is exclusive, and that's one of those things that we want to make available just to the members. And because I don't really know if anyone that's training on that. It's kind of a deep subject, but anyway, we're excited to be able to offer you something on that. And uh,
AOA.
basically, it's going to help you. It's going to help you know what to do and prepare you so that if anyone wants to come with a lawsuit regarding that specifically, you have processes and things in place, and they're gonna see that you're not an easy target. And so, anyway, but yeah, November 20th in San Diego, Sherman Oaks, and then also in Northern California, I believe on the 19th, we're going to be up there as well with a legislative update. So yeah, just a whole lot going on the in-person, and I hope that you don't miss those because those are really great times to be together and connect and learn a lot from landlord tenant law attorneys. So hope you're able to make that. And so now we can get to this. We thank you. A lot of you I see are in there on Zoom, and we'll take questions at the end. If you're on YouTube, you can put the questions in. If you're on the AOAUSA.com website, there's the blue help button. You can put your questions in there and they'll funnel that over to me. But let's try to save the questions until the end because he may answer your question. And then also, when you do ask a question, give enough detail so we know where you're at because it may make a difference and if you're subject to rent control or not. Uh, this really deals more with tenant protection ordinances than it does with the rent control, but yeah, just give us some information when you do put your question in so we have a little bit of context. And of course, this is not legal advice. Our speaker today is going to be sharing best practices and processes, but it's not specific information for you per se. Anyway, so our speaker today is really the king of evictions, I think. He's done, at this point, over 300,000, has 29 attorneys on his staff, and he is the author of the legal Q&A that is in the AOA magazine. You can also get that on our website. We have the magazine tab. You can get there and search that up. And anyway, you can always get that. So anyway, Dennis Block, thank you so much for being available. And how are you doing today, my friend?
I'm doing really good, and thanks, Jeff. I always appreciate the opportunity to do these seminars with you and your members. And for the members out there, the laws are so varied and so changing all the time that you really have to stay up on it. And the Apartment Owners Association is probably the premier organization for not only educating its members, but of course the credit checks and of course the forms that you have on your website are fabulous. Today, we're going to be talking about nuisance tenants and what you do with them. Nuisance evictions tend to be more difficult for a varied amount of reasons, which I'll go into. But as a general rule, unless the conduct of the tenant is outrageous, like, he beat somebody up or he took a gun to the common areas of the property and started shooting up the place. Generally speaking, if you can evict the tenant on something other than a nuisance issue, that's always best. So if in fact the tenant owes rent. Well, that's kind of black and white. He either owes rent or he doesn't owe rent. And if you can proceed on non-payment of rent, that's usually a better way to go. Or maybe they have unauthorized persons or maybe unauthorized pets or alterations. These things are kind of black and white. They either have them or they don't have them. And if you can prove that they are in violation of the rental agreement, then that's an easier way to go as opposed to a nuisance. Because you see, nuisance is a varied terminology to many different people. You can take a pin and drop it on the floor, and somebody might consider that to be outrageous noise, and someone might consider it to be nothing. So it's an issue where each case has to be evaluated separately to see if it rises to the level of what constitutes a nuisance, which is an unreasonable interference with the comfort, safety, and enjoyment of other residents. So that's what the issue is. So if the guy has, for example, a small methamphetamine lab on the property, just a small one, Jeff, and the police raid the unit, well, that's going to be an easy case for eviction. But the problem crops up is when tenants are bothersome to other tenants. But the issue is, how bothersome is that? If you have a guy who has, let's say, an outrageously loud party, okay, and he had one in January to kick off the new year, and now he's having another party for Halloween tomorrow, and he just bothered everyone in the building. People were up till 3, 4 o'clock in the morning. Is that going to be a case for eviction? And in my shallow opinion, that's not going to be enough because it's only two incidents. Okay. Now, certainly if he punched out another tenant, I don't need to have many incidents. So the issue is really what constitutes a nuisance. And then you're going to have your tenants are going to say, "Oh my God, this guy, he's he's scary or he's got all these unsavory people and I don't feel safe walking around the property." That means nothing to nobody, nothing to nobody, because their feelings are irrelevant. I don't care that the tenants aren't feeling safe or that there's these unsavory characters. They're coming up and I think they belong to a gang because they have gang tattoos. That means nothing. The issue is what did they do to you? Okay. Did they come up and threaten you with physical violence or possibly actually hit you? Or pulled out a knife or a gun or something to that effect? Or was the tenant having constant parties into the late evening? And this is happening on a regular basis, not just once every 10 months, but on a regular basis, like, hey, a couple of times a week, maybe 4 times a month. It's constantly. And when I tell this tenant to quiet down, then he gets angry and threatening. Now we've got a case for eviction. But it's got to be something that is substantial. It's got to be something that is happening, unless it's of a true violent nature, that's happening on a regular basis. When you have that, then we have to then figure out whether we have an eviction or not. So what do we do in that situation if you say, hey, yeah, that's what my tenant's doing. He's bothering people on a regular basis. People are coming up to me. It's tangible things like they're either threatening to me or maybe he's taking his garbage and throwing it into the rotunda on a daily basis, okay? Or maybe he's blocking my car on a regular basis so I can't get in and out, and then he's cursing me out. If that's happening on a regular basis, we've got a case for eviction. We have a case for eviction, but we're not filing an eviction yet. And the reason why we're not filing an eviction yet is because I need facts. So I need to know what day this occurred, what the tenant did, and who was the tenant, who was the witness, who was the other resident. So I need this list so that I can construct a notice. On the notice, which is a 3-day notice to quit, not to perform or quit, just to quit, I need to have the facts stated. I need to have what occurred, who was the witness, and when it happened. So if we don't have those firm dates, I can't construct the notice, and then we're not in compliance with the law in terms of most of the jurisdictions that have local rent control on that, and even under statewide rent control. So again, I need these tenants, the other residents who are being bothered, I need them to make a note of it, or when they tell you what the tenant did, then you need to write it down with the date and the name of the tenant and what he did. Like he cursed me as I was walking through the courtyard. Now, no tenant deserves to be cursed when they're walking through the courtyard. If it happens on one occasion, well, it's two people mouthing off. But if happening on a regular basis, and this is not the only tenant who he's coming to, then I've got a case for eviction. Sometimes you get whack jobs, as we call them, where in the middle of the night they're just knocking on other people's door, they're screaming, they're yelling inside their unit. These are all cases. Sometimes, there's the domestic disputes between the two partners in that unit, and you hear things crashing on the wall and screaming and cursing. And even though it's not directed towards the other residents, it still constitutes a nuisance. I can't get to bed and I need to be able to sleep. Now, in an apartment house, there's a certain amount of noise that people have to put up with. And that's because we're living in a multi-family unit. So the fact that he has his TV loud and it's 3 o'clock in the afternoon, you know what? I don't know that that's going to be enough. You might want to give the tenant warnings. But you see, when you're living in a multi-family unit, you have to put up with a certain amount of noise. It's not going to be like you're walking into a library or a convent, okay? So you're going to have to put up a certain amount of noise. But if it gets beyond that, then it becomes a nuisance. And again, it has to be on a regular basis. But I need facts in order to start this case. I need to know what occurred, when it occurred, and who were the participants and what the person did. Okay, now if you say he just stared at me, that's not going to do anything for anybody on this planet. But if you do have real threats of violence or noise, or where they're interfering with, coming and going because they're blocking your cars, or maybe they're tossing out stuff in the common areas. I have a case we're doing right now where I served a 3-day notice to quit based on nuisance. This tenant does not make any noise. This tenant pays their rent on time. This tenant has no interaction with any other resident on the premises. None. Parks her car in her correct spot. Okay. So what possibly could be the nuisance? What could it be? Okay. Again, no noise, no threats, no interaction with any other tenants, pays their rent on time. Okay. Well, this is what's happening. She's got bed bugs. I don't know whether she brought the bed bugs in herself on something that she brought from the outside, or they just happened to appear in her unit. She is refusing treatment. That constitutes a nuisance. Now, she's pretty clever. She says, I'm refusing treatment because the chemicals that they're going to use, I am highly allergic to. I would have to go to the hospital. So we said, okay, we'll put you up in a hotel for 3 or 4 days. No, it doesn't matter. Those chemicals are going to impact my life, and you can't force me out. And we said, okay, we have another idea. We're going to use heat treatment that has nothing to do with chemicals. So we're going to burn out those bed bugs. Well, she just refused again. And the next door neighbor, which has a continuous wall to them, is now having bed bugs. And when we tried to spray in this next door unit, the son came over and started threatening the pest control company. Very bizarre. So the issue really is that you can have, it doesn't have to be the typical situation. You can have a nuisance situation where you're just not allowing me to eradicate pests. And we all know that bed bugs just spread throughout the building, and where it can be eradicated in one unit quickly, if it spreads, it becomes a major issue. And why would anybody not want to treat for bed bugs? You're just dealing with insanity. But again, we're landlords. We understand about insane tenants. So that's a case that we're going to bring. Now, when I do a notice to quit that I have to serve on the tenant, that will be the basis of the lawsuit. Again, I have to state what the tenant did, the date that it occurred, and then I've got to put one more piece of information into that notice. I've got to put the tenants' names who are the witnesses. But so many tenants are afraid, I don't want to have my name in this. And if their name isn't in it, then we can't go forward with an eviction. And they're saying, look, if I put my name there, the guy's going to key my car, right? He's probably going to want to assault me, and I just don't need this. And then we would also have to tell the tenant, not only does your name have to be in the notice, but you have to come to court. Now, in most cases, the tenant doesn't need, the residents don't need to come to court because the case either settles or the tenant doesn't fight us. He just gets evicted without having the necessity to go to trial. But if this matter is not settled and the tenant contests the proceedings, I need to prove my case. I can't just have the landlord or the manager come up and say, well, the tenant in apartment A and an apartment B and apartment C are all complaining about apartment D. It doesn't work like that. I can't talk about what a tenant said. I need to have that tenant in court. So then you're going to say, well, if that's the case, I'll just have them sign a declaration. So this way they don't have to go to court because they really don't want to confront this person in court. Well, a declaration I can't use. Why is that? Well, under the evidence code, that's considered hearsay. That is, it's a statement offered for the truth of the matter stated outside of the courtroom. I can't do that. I need to have a human being in court. So I always like to have in this situation where the tenants, the residents, will write me a letter explaining what the tenant did. So I say, put it in a letter to me. Because this way, if I have it in a letter and he's complained about it a few times to me, I can ask that tenant to come to court. And if that tenant refuses to come to court, I can subpoena that tenant. I can subpoena everybody who signed a petition. You can have a petition how this tenant is bothering us every night, not letting us sleep, too much noise, blocking the driveway, having toga parties in the middle of the night. If anybody signed that petition, I can now bring them into court and I can put the petition or their letter to me and then on the stand, and then they're going to have to state what they told me. But again, in most situations when we do a nuisance case, I don't need the other residents to come to court. But we have to make it understood by these people that if push comes to shove, that we will need them in court. And if they're not willing to come to court, okay, then I have nothing. We are not going to be able to win our case. So we need to run this by the other residents to see if they don't mind their name being in the notice. Now, see, here's the problem with the way the legal system is situated. This is not to protect the tenant who we're declaring to be a nuisance. This should be to protect the tenants, the other residents in the building. But that's not the way the law works. So when these tenants who are being abused by this one tenant and they don't want to come and testify, say what happens is the good tenants leave your building and you're left with, Attila the Hun who's still there and will now start making it crazy for the rest of the residents who are there. See, that's the problem. I had proposed to the City Council of Los Angeles that if it is a nuisance tenant, that for the first year that I shouldn't have any reason, I don't need a reason to evict. Because first of all, if it's in the first year, the rent's going to be high anyway, so there's no economic advantage to evicting a tenant if they're in their first year. And then I added that if we are allowed to evict this tenant, then we can't raise the rent for that unit for 2 years. We're going to agree to that because it's difficult to get other residents to come to court. And it's also difficult for us to allow their names to be put into a notice when they're afraid of this tenant who's creating the nuisance. Now, some tenants, please put my name in. I'm willing to go to court. I need this guy off my property. And that happens in a lot of cases too. Not all tenants are afraid of these people, but there is a good percentage of residents that are afraid of these tenants. So you need to inquire of that. But the first thing you need to do, the first thing is you need to document everything. Every single event. I have some clients who are so good on this. They'll give me a laundry list going back to 2023 of all the incidents. That makes my case so much easier when we do pull the trigger and start start an eviction on this. So we need to document everything. Also, it's a good idea when the guy was up to the middle of the night creating all this havoc and the police were summoned to the premises. It's a one-time thing. You need to write a letter to the tenant, documented that you upset the whole building based on your activities, and this cannot happen again. So you start documenting this by sending letters to your tenant explaining what he did and how this conduct is totally unacceptable for a multifamily building where you're living in. And this cannot continue. Otherwise, we're going to be forced to do an eviction. This shows your good faith. And if you do this on a couple of three of occasions and then we start a lawsuit, trust me, we're going to have an easy lawsuit to proceed against these tenants. But again, without documentation, without the true facts, I have it where they clients will call me up and say, all the tenants are complaining. He's got people coming in at 12 o'clock midnight, at 1 o'clock in the morning, all these people just walking right in. And I'm thinking to yourself, well, maybe he has a Bible study class at midnight, and that's what he's doing. They're coming into his unit. Well, I know what he's doing. Well, we all know what he's doing, but the reality is he's going to make the argument that it's a Bible study class, and these people are coming in there to get to read their portion of the Bible. And that's about it. The issue is not that they're coming in the middle of the night. The issue is not that the guy's walking in his apartment at 3 a.m., because quite frankly, you can walk in your apartment at 3 a.m. The issue is how is that being disturbance? And again, we have to make it where common disturbances which occur in a multifamily building have to be accepted. So people are going to maybe exercise in the middle of the night and they're on an incumbent bike or something. But again, you're going to hear some noise and you have to put up with it. We have some people that have a washer and dryer in their apartment and they use it at 3 a.m. And is that really going to be considered a nuisance? You supplied the washer and dryer. Maybe their schedule is such that they want to put it on. Is that bothering other tenants? Absolutely. Is it grounds for eviction? A really tough case. And then when that happens, I then advise my client to go outside the law. Go outside the law. So what does that mean? Pull the plug on the wash. No, don't do that. What outside the law means, maybe you need to soundproof that room. Maybe for the kids that are running in the apartment, maybe you need to put in some carpeting at your expense, landlord. Do the soundproofing on the walls, and maybe that will solve the problem. Okay, maybe you can relocate a tenant who's really bothered by this, assuming there's another unit in the property, to a different location. But not everything constitutes, a nuisance. I had another client call just last week, and they have a tenant complaining that a family moved in, a mother and three children moved in, and the noise level is insane, so says the tenant underneath. They're running, they're screaming, they're banging on the walls. Well, here's the problem. In the state of California, in the state of California, it is discriminatory if you choose not to rent to children. It is discriminatory if you choose not to rent to children. So that means you have to rent to children. Now, you're not going to believe this, Jeff, but children are going to act like children. Do you believe that, Jeff? Do you? Okay, well, they're going to act like children. So if you have to rent to children and children are going to act like children, then guess what? They're going to be playing outside, riding their bicycles, throwing the ball against the wall. Nothing you're going to be able to do with that. And of course, if the children are screaming at 2 a.m. in the morning, I think that's a problem. If they're banging on the walls, I think that can be controlled. But for the most part, the yelling and the horseplay that kids are going to do in the unit, that's protected conduct because you got to rent to children and children act like children. So these cases have to be evaluated on a case by case basis to see if you qualify for an eviction. Again, I'll recap that if you can evict them on any other reason, which is black and white, I would definitely go that route. Unauthorized people. Oh my God, the guy changed the locks to the front door. That's an alteration. I can evict on that. It's black and white. You either changed the locks or you didn't. You brought in an extra dog or you didn't. These are black and white things. People say they brought in a dog. How do I prove that? It's so simple to prove that. Knock on the door. The dog will bark. Okay, it's very simple to figure that one out. Or people, extra people. How do I know they're living there? They come and they go. You'll see them in the morning. You'll see them in the evening. You'll see them taking their key, putting it into the door. And if you know that they drive a yellow Camaro and you see the yellow Camaro parked overnight, guess what? They're living in your unit. So these are much easier cases to prove. But I don't want to dissuade somebody from going forward with a nuisance case. If in fact other tenants are complaining, then you actually have an obligation under the law to make a peaceful enjoyment atmosphere for your other tenants. That's your obligation, and you can get sued if you don't. But the issue is, does the conduct of the bad tenant rise to the fact of really constituting a nuisance, a substantial interference with the comfort, safety, and enjoyment of other residents? I had a judge. I'll even tell you his name. It was a commissioner, and I hope he's listening to this. And absolutely no relation to me, but his name is Mitchell Block. He was Commissioner Mitchell Block. He was out of the Van Nuys Court. We had a case where a tenant punched the manager in the face, and this Yahoo judge, who I'm socially friends with, said that's not enough. Now, that judge was out of his mind on that occasion. Okay, once is enough. You get punched. That's enough for me. And any other judge would have thrown him out, but Commissioner Mitchell Block didn't. And I do hope he's listening to this podcast because I was outraged at my social friend for ruling against me. Shows you what kind of nepotism. There was no nepotism because he ruled against my client, which was a total mistake. But again, it does have to rise to the level of a nuisance. If you have these situations, please document them, send warning letters to your tenants, get your other residents lined up, and then what do? You got to run it by an attorney, such as my law firm, and we'll tell you whether you have a case or not. I can tell you that of the nuisance cases that we get questioned on, I would say about 60% we say you got no case. And our potential client is outraged at that. But there's really nothing else you can do. I am not going to take a case. If you take a case against a tenant who you're declaring to be a nuisance, and that tenant wins, it's really bad for the residents, and it's really bad for the homeowner or the apartment house owner because the guy thinks he just beat up your good-looking attorney, and I do mean good-looking. And then he's going to basically rule the roost at that situation. So our practice is such that if we take a nuisance case, we really believe that we have enough to go forward and to evict that tenant. And that, ladies and gentlemen, constitutes the sum total of all knowledge that I have on evicting a tenant for a nuisance. And Jeff, if you want to open this up to questions, I am going to happily answer them for you.
Cool. Yeah, there's definitely tons of questions on this. We get a lot of questions about it. And yeah, where'd you come up with the yellow Camaro, you know?
Was the first thought that came to
Yeah,
mind.
I know. I'm just like, it's so random, but it's great. Yeah, so we do have questions here. Let's see. Can I use video instead of trying to collect human witnesses? Well, I think you know what they mean. Can they video the renters uh, saying
Well,
that,
again, I mean, a video is not going to necessarily show. I mean, what is the video going to show? Is it going to show that he's blocking the driveway? It can't show that there's too much noise. Could it show that he took a knife out and tried to stab a resident? That would probably be good, but that's about the size of it. By the way, anybody who's in the Zoom meeting room, if you want us to call on you, on the toolbar on the bottom of your Zoom meeting, you
right?
can click that raise your hand, and we'll call on you directly. Otherwise, we're going to read what you wrote in the chat room, or if you're on YouTube, we'll get your questions from there.
All right. Yeah, here's the chat. Okay, how do you deal with residents who make repeated frivolous complaints against their neighbors. So here's the opposite side. They want things to be quiet at all times, even though their kids, even though there are kids in a multifamily building. So you talked about it, but how do you deal with those? How would you address those?
I would write a letter to the tenant and I would say something to the effect of, look, you are in a multifamily building. And in a multifamily building, you have to put up with a certain amount of noise, not outrageous noise. And I deem that what you're telling me about is not outrageous. It's the same amount of noise that you would expect in any multifamily building. And if you want to have total quiet without any interference by anybody else, my suggestion would be to go buy yourself a 1 acre lot, put the house right in the middle, and put a moat with alligators around the lot, and you will not be bothered by anybody. But that might be expensive to do that. So if you're going to live in a multi-family building where you're going to be paying less for your housing expenses than in that 1 acre lot, then you are going to have to put up with certain amount of noise. And based on what you're telling me and what I'm hearing from no other resident, because nobody else is complaining. You're just going to have to put up with this. But if you're on a lease, I'll be happy to let you off that lease. So that's something that we would say to the tenant.
Great. I see. Yeah, go ahead and share there. I can't see Sedalia.
Mhm. So I have a tenant who has two dogs who got outside in the backyard. And he said, I need a new wrought iron gate. So I went by and it looks like the dogs had put a hole in the wrought iron gate. And now I don't feel like I need to. He needs to fix that. His dogs messed it up. I don't think I should have to do that. I mean, plus the lease has no pets, but
Okay, well, they're not allowed to have pets?
well, the lease says no pets.
Okay, and you've never authorized that.
No, but now that they're tearing up, it's like you need.
Well, obviously that would be grounds for eviction if they brought in an unauthorized pet, such as a dog. I'm curious how a dog could chew through a wrought iron fence, but assuming he did, then of course the tenant is also responsible for the act. So I might tell the tenant in a formal notice, number one, get rid of your dog so they're unauthorized. Number two, here's the bill that for the expense of fixing that wrought iron gate, and if and I want to get compensated for that as well. So that this is certainly a case for eviction.
Gotcha. Thank you.
Okay, thank you.
I mean, hopefully she knows that number to call. It's down there at the bottom of the screen. Okay, all right. And then we have, if you know about the nuisance, this is a good question by Mary. If you know about the nuisance tenant, do you have to disclose this to prospective tenants?
Well, if you know about the nuisance tenant, then you should be doing something about the nuisance.
The person that it doesn't cross, they're a nuisance, but you can't evict them. Yeah. So it's that kind of person
Well,
that just,
if it's not a nuisance, then there's nothing for me to tell. If it
okay.
is a nuisance, then hey, landlord, do your job. Get rid of this person.
All right. Okay, how many complaints or warnings should be issued before a notice to cure or quit can be served?
I don't think you need any warning notices. There's some jurisdictions such as Santa Monica where you have to serve a warning notice first. But for example, in Los Angeles, if they're parking two cars on the premises and the rental agreement says only one car is allowed, you can immediately serve a 3-day notice to get rid of the additional car.
Great. What if the problem with what? I can't read this very well. What if the problem with roaches or nuisance lives below the manager and the manager is a witness?
Well, the manager certainly is a resident, and any resident can complain if in fact the tenant is creating a nuisance. I do want to back up a little bit, and that is, I want you to understand that there's a difference between a notice to perform or quit and a nuisance notice. One says, hey, get rid of the dog in 3 days. If they comply, then there's nothing wrong. Get rid of the extra person. A nuisance doesn't say that. It's a 3-day notice to quit. And generally, if you're dealing with, it has to, on a notice to perform or quit, you're dealing with things that you can touch, like an extra person or you change the locks, you're not going to give a person a 3-day notice to perform or quit to stop making noise. It just doesn't make any sense. Because if they're quiet within the 3-day period and they're quiet on the fourth day, but what if they're noisy on the 10th day? So noise, you can't touch noise. Noise is based on nuisance and it has to rise to the level of the nuisance. You might give them a warning letter, but you're not giving them a chance to correct it, where, as in a notice to perform or quit, where you're giving them a chance to correct it. Does that make sense?
Absolutely. All right. I had a tenant that had a film crew come and film in her apartment without asking. What is my right with this situation as the landlord?
Probably nothing you can do. It was a one-time incident. What you could do is you could potentially sue that tenant for the remuneration that she got. I'd file a small claims court and say you had no authority to do this, and you need to disgorge all the profit that you made by allowing my apartment building. Now, most filming crews, assuming it was a professional filming crew, would always go to the owner first and get permission.
Right.
So, but this might have been, some back alley production company, and didn't really care about that. So, but I know, for example, just this about 2 weeks ago, I got hit up to talk about by Hulu and ABC, to record a piece dealing with a tenant whose name is Ellie Mae McNulty, who I've evicted about 5 times. They're going to be doing a piece on her for ABC and Hulu, and so I'll be a featured speaker on that one. But the interesting part was they just rented a private home, and the piece was done in this private home. It was a private production company being hired by Hulu, but of course they did pay the owner of the house. They rented the house, and they had all their equipment in there.
All right. What happens when an upstairs condo has owner harassed the tenant below for them for normal living noises and threatens suit?
Well, who's threatening who? You're saying the owner's threatening the tenant?
Yeah, the upstairs condo owner is harassing the tenant
Oh,
below
I
for
see. So it's a
regular
different, if it's a
noise.
different owner.
Yeah.
Well, I would just write a letter saying, stop harassing my tenant. The noise that they're making is not out of the ordinary, and no other person is complaining. It's weird when the upstairs neighbor
Yeah.
is complaining. Usually it's the downstairs neighbor by walking on the floors or adjacent neighbors with the common walls. So unless the downstairs tenant's taking a broomstick and hitting the ceiling with it, I'm not sure how that could be. But if they're complaining, then then I would say you've got to understand that you're in a multifamily building and there's a certain amount of noise, and do what you got to do, but stop harassing my tenant or I'm going to file a lawsuit against you.
Yeah, when it comes to this question is really what is admissible in a court? Can a documentation from witnesses be in an email?
The answer is no. We talked about that. It has to be a live person in court because under the law dealing with hearsay, you have to be able to confront your accusers. And just looking at a piece of paper where they say this guy's really bad, I don't like him, he's making my life crazy. You have to have that person in court.
But because that was in an email, did you say that they could subpoena that person to court because it's
Yes, you could
in
always
writing?
subpoena that person to court.
Mm.
Some of these things can get in by what they call a business record. Like, hey, this tenant sent me this, so I'm going to introduce this as a business record. But it's just doesn't get to the level where I'm going to be able to prove the nuisance.
Okay, let's see. Okay, how to handle a tenant that is being a nuisance by complaining incessantly about neighbors for alleged noise issues and guests. It happens from time to time, not rising to the level of nuisance. Is the landlord liable to do something about the tenant's complaints? So a lot of
Well,
people are having the
are the
same
complaints
question
coming to other tenants or is the complaint coming to the landlord?
to the landlord, sounds like.
Okay, well, if the complaints are coming to the landlord, then tell the landlord to ignore it. Just say this is normal behavior. Sometimes, though, these tenants will start accusing other tenants in the building of, hey, you're making too much noise, and the other tenants will be dumbfounded and say, I haven't done anything. Well, you're walking in your unit at 10 p.m. Well, so. So I write a letter to the complaining tenant at that point, which will say something to the effect of, you have no right to confront any other tenant in the property. All questions regarding to the management of this building must go to the landlord or to the landlord's agent. You
Mm,
make the complaints to us and then we'll address it to other tenants. But if you start talking to other tenants in any kind of a fashion and demanding things, that's going to constitute a nuisance and we'll be evicting you.
okay. Let's see, Kevin Perez. Uh, LA City RSO rent increase. What notice should I serve the tenant and what should I send to LAHD?
Okay, you don't have to send a rent increase notice to the Los Angeles Housing Department. You just got to mail it to the tenant on the AOA website. You can get a rent increase form. If it's going to be the city of Los Angeles under RSO, it's 3%. And all you have to do is mail it to the tenant, but don't forget the 5-day mailing rule. So, for example, if you wanted to make this effective as of December 1 and today is October 30th, you'd have to hand it to the tenant. If you mail it to them, then it's not going to become effective as of December 1 because it's more than 35 days that you would need to have that effective. So this would then, if you mail it now, it would have to be effective as of January 1st of 2026.
All right. Okay. How much luck have you having eviction tenants that have unauthorized people living in the apartment? One person on the lease ends up 5 people. Also, does it matter if unauthorized are minors or kids?
Okay, so number one, an occupant under at least LA rent control has to be there at least 30 days, and then they change from guest to occupant. If it's a child born into the unit or the tenant's children, I wouldn't touch that. However, if an adult moves in, even if the adult is the tenant's child, but it's an adult, then if they're there for 30 days, then at that point in time, you can issue a notice to perform or quit, giving them 3 days to get rid of the unauthorized person.
All right. So let's say there's this nuisance tenant, but there's Section 8. What's the process for them as opposed to the regular process for a non-Section 8?
There's no difference. It's still a 3-day notice to quit. The only slight difference would be that you would have to send a copy of that notice to your Section 8 advisor. And then with your 3-day notice to quit for nuisance, you have to have it accompanied by the Women's Against Violence Act. It's a form that needs to accompany any termination notice that you serve on any Section 8 tenant.
Okay. All right. How to evict a hoarder tenant? That sounds like a title for a future live stream.
Now, a hoarder is an interesting question. And is that constitutes a nuisance? Or is that something that can be corrected? Now, you could make an easy argument that it is a nuisance. You know, number one, it's a fire hazard. Number two, what happens in these types of situations is that it's easy for it to become a pest infestation, which then will migrate to other units. So you could consider that to be a nuisance and just serve a 3-day notice to quit. However, I wouldn't recommend that for a hoarding situation. I would serve a 3-day notice to perform or quit, giving the tenant 3 days to uh, have the premises returned to the state of a neat and sanitary condition. Now, you have to have a rental agreement. Every rental agreement, and of course the great AOA rental agreement, all states that the tenant is charged with keeping the premises neat and sanitary. And that constitutes something other than neat and sanitary. Usually, when you have a hoarding situation, these people have just basically a small path upon which they can navigate the unit. Usually, the windows are sealed with stuff in front of them. In some rooms, they can't even get into. This is definitely a sickness. But again, this creates a fire hazard. And again, it would be a violation of your rental agreement. So, on that basis, we would be serving a 3-day notice to perform or quit. And at the end of the third day, then we go in there and we commence the eviction. Now, I always have clients and they'll tell me, gee, it's a hoarding situation. And I'll go, okay, so what's going on? You go, well, you walk in and you can't believe what you see and the filth and the grime and this. And I go, that doesn't tell me anything. I want to know what you see. I want you to tell me that there are boxes stored to the ceiling, that there's papers all around, that there's rotting food in the sink, there's rotting food and feces on the floor. I need to know that because that's the information I'm going to put into the 3-day notice to perform or quit, which will give them then 3 days to clean that mess up.
Right. Great. Let's see. Yeah, there's different questions here. They're not all totally related. I think a lot of these things, it's just how to handle people, and it's not necessarily a legal thing. Um, yeah, the question about we get this question a lot. How do you get your renter to follow through and get renter's insurance? And we know that you can't evict for them not getting renter's insurance. Do you have any way to
We,
persuade people on that one?
yes, every rental agreement should require that the tenants have renter's insurance, that the renter's insurance should not only cover any damage to their personal property through no fault of the tenant, but should also cover the cost of temporary relocating. For example, if the unit becomes flooded and the tenant has to leave, that renter's insurance policy that you're requiring the tenant to have would also be responsible for taking care of the cost of their temporary relocation. Now, Jeff is right that you can't evict under California law based on a case that came down because it's not considered a substantial breach of the contract. But the reason why you want to have that in your rental agreement, or you can do it as a change of terms of tenancy, as long as the tenant's on a month to month requiring that. The reason why is if the tenant then sues you for all the treasures that got ruined when the flood occurred in the unit, or if the tenant had to temporarily relocate, and of course the tenant wants to, of course, like my daughter, stay at the Ritz-Carlton or the Four Seasons, that you would not be responsible because the tenant was charged with having renter's insurance to cover that. So if the tenant doesn't have that, it makes no difference to you. It's okay, but now he can't sue you because it was his obligation to have that insurance.
Yeah, and I guess yeah, just a little bit off the topic. I hear they're trying to get rent control in Burbank where you're sitting.
I am sitting in Burbank and they are trying to get rent control here. And there's been a lot of landlord groups that have been fighting that, but we'll see. But you guys out there
We can they
with
can't they showed
property,
up. They showed up yesterday, big
yeah.
time. They had like 60 or so people. Burbank's a really is really small actually. So to get 60, that was a pretty good number. We were there and just
Yeah,
all
but
coming together.
we have one buffoon here in Burbank. You know who that is?
Just one, Constantine? There's more than
Uh,
him.
the guy's name is Adam Schiff. But,
Oh, okay. Now I know what you're talking about.
but other than that, that's my own political position, not the position of the AOA or its affiliate.
Right. And I'll ask you this one. Well, so also I just want to mention this because people are watching from all over. LA City Council has a meeting next week about lowering the rent increase as if it wasn't low enough and as if it hadn't been frozen for years already. So that's one to weigh in on to get down there. I know the tenant rights groups are planning on showing up there, and we all need to show up there as well for sure for that one. And hey, Dennis, can you tell me how are you going to vote on 50, man? I think I know the answer.
If anybody has seen my Saturday show, which I do at 3 p.m., and you can catch it, the previous shows on YouTube, or watch it live by going to my website, evict123.com. The last two shows have prominently required people to vote no on 50.
Yeah, we're definitely a no on 50, and we're going to be sending something out and as far as reason why on that. All right, you got a time for a few more of these?
Sure.
Okay. What is the difference between a 3-day notice to perform or quit and a nuisance notice?
I think I just went over that.
Yeah.
Again, In a perform or quit, you're giving the tenant a chance to comply. There goes my Alexa. Somebody, uh, if you're giving the tenant a chance to correct the situation, like get rid of the dog in 3 days, but a nuisance, and I'll use this. Let's pretend you have a tenant who in the common area shoots 3 people. Okay. Most people would consider that a nuisance, but you certainly wouldn't consider serving them a notice to perform a quit. Now, don't shoot any more people within the next 3 days. And I think that kind of typifies the difference between the two notices.
Okay, here's a good one. I have a tenant in unincorporated LA where there have been about 50 calls to the police department in the past year. Do I need to list every single incident in the notice?
No, I would just list, you don't have to do every one, but do 10, okay? And I think that's sufficient to do that, okay? But I have clients who have this laundry list and we list them all going back to 2023, and but you need to have current ones as well, of course.
Right. And here's a unrelated question, but a tenant moved in the sun during COVID with a dog. Can I evict them yet?
Well, if he brought in the dog under the city of Los Angeles because of COVID, then you can't evict him for that.
So there's no sunset on that one, huh?
No, not that I'm aware of.
Yeesh. All right. Okay, let's
Let's
see.
take one more, Jeff.
Okay, this is it. It's a follow-up on that one question. The one tenant on a lease, a year later, he moves in 2 kids, like a 10-year-old and then one adult in a 1 bedroom. So
Well,
now there's
is
two.
I don't know if a stranger moved in with his child, then you could immediately evict for both of those reasons. But if the adult moved in and maybe the child was the actual tenant, I would just go after the adult and I would state to your tenant, you have 3 days to get rid of that adult person.
Right. So that's an unauthorized occupant, right?
Yeah.
And what's the timeline in LA for there's like a window from when you realize that they're in there?
Okay, I think you're confused that
I
they have to
did.
be there at least 30 days. But if the rental agreement says that you can get an extra 10%, then
Oh,
once
that's
that
right.
tenant has established residency, then you have 60 days to serve that rent increase notice. If you don't, then you don't have the right to raise the rent. But even after the 60-day period, you still have the right to bring forth an eviction to get rid of everyone from in the unit.
That's right. If you want that, if you want to just take a 10% increase, you could do that, but you would need to run them, you'd want to run them through the screening process
You got
for
it.
sure. Hey, Dennis, I thank you for being available for us. We're gonna have you on next month too.
And I'll remember this time.
Yeah, at the end of the month. Anyway, yeah, lots of thanks and hearts and stuff going up in the Zoom. Guys, if you're on YouTube, definitely do the Zoom one for sure because we're looking at those questions first. Thanks again, Dennis, so much. And I'm very excited for this next issue of the AOA magazine. You got to read the president's message. So all that is just a little hint. Take a look at it. Take care, everyone. Bye-bye.
Take care.